Today we're talking about this story. FTC sues John Deere over its repair monopoly. John Deere has been allegedly woefully underserving the independent repair technician, independent repair products market. They're basically not supporting right to repair the way they said they were going to. This is not the free market. This is unfair competition. This is illegal tying of repair services to the manufacturer. So let's take a look at what they have to say. So this is the Federal Trade Commission and the state of Illinois and the state of Minnesota versus Deere and Company. For decades, defendant Deere and Company, a manufacturer of large agricultural equipment, including tractors and combines, has throttled the ability of farmers and independent repair providers, we're going to call them IRPs, to repair Deere equipment, leaving farmers wholly reliant upon Deere's network of authorized Deere dealers for many key repairs. Deere's increasingly sophisticated agricultural equipment requires a software tool to diagnose and repair problems that relate to electronic functions. And only Deere has the information and knowledge to create this essential tool. By making this tool available only to Deere dealers, Deere forces farmers to turn to dealers for critical repairs, rather than complete the repairs themselves or choose a repair provider that may be cheaper, closer, faster, or more trusted. Deere's unlawful business practices have inflated farmers' repair costs and degraded farmers' ability to obtain timely repairs, which is especially critical in times of planting and harvesting. Deere is the world's leading manufacturer of agricultural equipment like large tractors and combines, and Deere enjoys a dominant share of large tractor and combine sales in the U.S. Deere distributes its equipment and related parts in the U.S. through a network of authorized dealers that promote and sell equipment and parts and provide repair services to farmers. Deere appoints dealers to act as its authorized dealers, oversees changes to its dealers' ownership and business structures, and has contractual rights to redacted. I'm assuming it says something along the lines of terminate dealerships when they see fit. Deere also requires their dealers to actively and aggressively promote Deere parts. Durable, reliable, and easily repairable agricultural equipment is critical to American farmers' ability to profitably produce their crops. Planting, spraying, and harvesting are all weather-dependent and time-sensitive processes. When these activities are interrupted by an equipment malfunction, farmers must be able to restore their equipment and resume work quickly. It's also a seasonal business with periods of downtime during which farmers can make use of their own labor and know-how to perform maintenance and repair of their equipment and minimize the risk of equipment malfunction when the equipment is needed most. For these reasons, many farmers have historically developed and relied on their own ability to repair equipment in the field or on the farm. Farmers have also relied historically on local independent providers who offer competitive advantages compared to dealers, including lower cost, proximity, speed, and reliability. In the past, those farmers who chose to rely on Deere dealers have benefited from the competition those dealers face from independent providers and the ability of farmers to self-repair. But in recent decades, Deere has increasingly computerized its agricultural equipment, with numerous functions being performed by electronic control units, or ECUs. As a result, repair of Deere equipment is no longer purely mechanical. Such repairs now commonly require interacting with onboard equipment software to diagnose a problem or calibrate or reprogram any affected ECUs contained in the equipment or replacement parts. This in turn requires the use of an interactive software tool, the repair tool, that is able to communicate with the equipment's onboard systems to perform diagnosis and repair. Deere has monopoly power in the market for fully functional repair tools capable of enabling all repairs on Deere agricultural equipment. Only Deere has the required information and knowledge to develop a fully functional repair tool for its equipment. Deere has developed such a tool, which it calls Service Advisor, the Full Function Service Advisor, which Deere makes available only to its authorized dealers. Deere has also developed an inferior repair tool that is not capable of enabling all repairs on Deere agricultural equipment. This is called the Customer Service Advisor, which is now available to farmers and independent repair providers. This tool lacks many of the key functions necessary to enable comprehensive repairs. Deere also fails to, redacted, as equipment manufacturers in the automotive and trucking industries do. I'm assuming it says something about providing this equipment and training to independent repair technicians. Because Deere makes its fully functional repair tool only available to its dealer network, farmers and independent repair providers are unable to perform certain essential repairs and thus unable to competitively constrain Deere dealers in the provision of these and other key repair services. So we're closing the market. It's not a free market. It's a closed market now, thanks to this tool not being available. Farmers are forced to turn to Deere dealers for repairs that they would do themselves, or take to an IRP but for Deere's restrictions. As a result, Deere has acquired and maintained monopoly power in a relevant market for the provision of repair services that require the use of a fully functional repair tool. Through its limited distribution, Deere controls entry into and limits output in the provision of such services. Deere's dealers are able to maintain a 100% market share and charge supra-competitive prices over the competitive price for restricted repairs, and Deere itself reaps additional profits through parts sales. And the effects of Deere's conduct extend beyond the market for restricted repairs because farmers and IRPs cannot always know, at the time of a malfunction, whether repair will ultimately require dealer involvement. And because farmers sometimes prefer to have all repairs performed by one provider in one trip, Deere's repair restrictions steer additional, non-restricted repair business away from self-repair and IRPs and into Deere's dealer network. So in other words, they want to get everything fixed in one trip. That means you got to have the one guy who can do some of the repairs do the rest of them as well. Deere's restrictions deprive farmers of the use of their own repair labor, deny them access to their preferred repair service provider, prevent them from more reliably planting, spraying, or harvesting crops on a schedule that would allow them to maximize yield, and force them to spend more on repair and parts. Deere dealers charge more for service than IRPs, with only one internal Deere analysis identifying, it's redacted, I'm guessing something of a discount. And unlike farmers and IRPs, Deere dealers are almost always they almost always use more expensive Deere-branded parts, so no third-party parts then either. No unauthorized parts. Deere's restrictions harm farmers, an executive explained in a redacted quote that we don't have. Deere's practices have generated an outpouring of public concern from farmers and repair providers. Aggrieved farmers have mounted an extensive state lobbying campaign in support of right-to-repair legislation across the United States, leading to recent legislation in Colorado. Deere has responded to public outcry regarding its repair practices with its own intensive lobbying against right-to-repair legislation, accompanied by a series of half measures and unfulfilled promises. For example, instead of making a fully functional repair tool available to farmers and IRPs, Deere released Customer Service Advisor, knowing that it was hampered. With great fanfare, Deere entered into a memorandum of understanding with the American Farm Bureau Federation. So they made an agreement regarding repairability of agricultural equipment, but still, Deere did not make a fully functional repair tool available to farmers or independent providers, claiming that the MOU only required the provision of the degraded Customer Service Advisor tool. Deere invoked its release of Customer Service Advisor and its Memorandum of Understanding with the Farm Bureau to stymie state right-to-repair legislation that would have otherwise been passed. Deere also raised unfounded environmental safety and intellectual property concerns as a strategy to publicly defend its repair restrictions and to combat state right-to-repair legislative initiatives. Deere's continuing invocation of these concerns is pretextual. Like Deere does elsewhere in the world and like original equipment manufacturers do in the automobile and truck industries, Deere could enable repairs by equipment owners and IRPs without undue risk of violating environmental laws, risking operator safety, or compromising intellectual property rights. In light of the unfair and anti-competitive conduct alleged herein, plaintiffs seek an order from the court enjoining Deere from engaging in such conduct, ordering Deere to make all repair resources available, and ordering any other equitable relief as the court may deem appropriate. Now that's interesting. This is equitable relief that they're asking for. They're asking for an injunction. I don't see anything in here about money. If Deere wants to compete for repair services, they need to compete on time and reliability and quality and price and all that stuff, not on we made the thing, so now we can prevent you from fixing it. That's not correct. Of course, there are lots of things that this applies to. And yes, the government has to pick and choose its battles, and customers have to pick and choose their battles. I can't repair my one wheel, for example, very easily. But that, I'm not going to go to court over that right now. Although, I came close a couple times. That's a story for another time. Count 1, monopolization of restricted repair services market arising under Section 2 of the Sherman Act. Section 2 is the anti-tying provisions. So you're tying two things together that should not be tied together. You can't buy Coca-Cola unless you also buy another product that Coke makes, the Coke soap or something. I don't know. There's a point at which you have such a market share for a product that when you try to tie something else to it, it's illegal. You have strong monopoly power in the market for large tractors, and now you're tying repair services to that as well. You can't get a John Deere tractor unless you also get John Deere services. Deere has willfully maintained its monopoly power for restricted repairs. Its conduct has harmed price and non-price competition. There's no sufficient justification, and it violates Section 2 of the Sherman Antitrust Act. This is just a pleading stage. They don't need to win their case here. The government just needs to tell you what's going on, not win their case. They get to win their case in summary judgment or at trial a few years from now. This second count is unfair method of competition. This is Section 5 of the FTC Act. I'm not familiar with this, but I'm assuming it requires you to have competitive conditions in the market. Deere derives an economic benefit from the degradation of competitive conditions in the market for restricted repairs. That degradation increases Deere's part sales. There is no sufficient justification. And then they add the State Antitrust Act. So Illinois is suing, so there's this Illinois State Antitrust Law, Minnesota State Antitrust Law. And here's the prayer for relief. So what are we asking for? Are they suing John Deere into oblivion, going to shut down the company? No, it looks like it's just an injunction. Plaintiffs, FTC, Illinois, and Minnesota respectfully request that the court enter final judgment against Deere, declaring, ordering, and adjudging Deere's conduct violates Section 2 of the Sherman Antitrust Act, Section 5A of the FTC Act, the Illinois Antitrust Act, the Minnesota Antitrust Act, that Deere is permanently enjoined from engaging in this unlawful conduct, that it's permanently enjoined from engaging in similar conduct, and that it is ordered to make available to owners of Deere large tractors and combines and independent repair providers on reasonable and non-discriminatory terms, full function service advisor and any other repair resource that it makes available to its dealers so as to enable agricultural equipment owners and independent shops to perform the full range of repairs that a Deere dealer can perform on Deere large tractors and combines, including without limitation access to reprogramming capabilities, conduct all tests and calibrations, support solutions, and the help desk feature. Any preliminary or permanent equitable relief necessary to redress and prevent recurrence of Deere's violations, any preliminary or permanent equitable relief necessary to restore fair competition, civil penalties sought by Illinois and the state of Minnesota, an award to plaintiff the costs of the suit for Illinois and Minnesota, and any other relief the court deems just and proper. Amazing. The state of Minnesota, the state of Illinois, and the Federal Trade Commission trying their damnedest to get John Deere to treat repair shops on an equal basis, which just blows my mind, because why would you need to block independent repair shops in such a way? I bring my car to the dealership for repairs when I think that's the best place to bring my car for repairs. But I would really hate it if I had to bring my car to the dealership because the dealership blocked everyone else from repairing the cars. And then once they've blocked everyone else from repairing the cars, they can charge whatever price they want, especially charging a high enough price that they make significant profits. More significant profits than they would have made if there had been healthy competition in a appropriately free market. So, This is great. I wish there were more civil penalties brought, but I guess the FTC is leaving that to the states of Illinois and Minnesota. They're really only asking for the full function service tool to be made available. And then I guess the states get to have at it with John Deere and their civil penalties. So that's all I have for you today. I'll keep you updated on this case. Anyway, so let me know what you think in the comments below, and I will see you in the videos on demand that drop. I love you all. Have a good evening. I'm Leonard French, your favorite copyright attorney. This is Lawful Masses, and I'll see you later.